The Court of Appeal in for the 5th District in the state of Florida is now in session. The Honorable Harvey L.J., Judge presiding. All persons have business before this court draw near. Give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Thank you all for coming back, and we will now start our last oral argument of the morning. It's still morning. The case number is 237746 USAA Casualty versus Emergency Physicians, Inc. As you may have heard, and maybe you weren't here when I started, we will assume 5 minutes for rebuttal unless you tell me otherwise.
Yes, Your Honor.
All right. Thank you.
Okay.
Please proceed.
May it please the court, I'm Nancy Copperthwaite on behalf of Appellant USAA Casualty Insurance Company. This appeal arises from what should be a simple PIP claim. Emergency Physicians, the provider, as assignee of Lauren Frazier, sued USAA alleging it breached the insurance contract with Frazier's mother, Lish Adams. The provider's claim, like all insurance claims, depends on the existence and the terms of the policy. Yet paradoxically, the provider moved to strike the policy's declarations page, which sets forth the key information about Adams' coverage. And the provider now asks this court to ignore the essential part of that policy. The record in this case is filled with error, and the error begins with the county court's decision to ignore the certified policy, which clearly shows a $1,000 deductible elected by Adams for herself and her daughter. Because the provider presented no evidence whatsoever to rebut the terms of the policy, including the deductible, the court should have granted summary judgment in favor of USAA, and this court should reverse based on this policy issue alone. If so, it need not consider the additional factual and legal errors in the summary judgment order. Each of these errors is grounds for reversal, and the combination of the errors warrants a reversal and remand in favor of USAA with directions to enter judgment in favor of USAA. If there are no questions on the contract issue, I'll turn to the next, to the provider's primary claim, which was also the county court's ruling regarding the deductible statute. That ruling, again, is a legal issue that warrants reversal and remand in favor of with directions to enter judgment in favor of USAA, because that's a pure legal issue. As the county court itself acknowledged and said in its order, the deductible statute does not specifically state that a signed election selection form is required for a deductible. That determination should have been the end of the court's inquiry, but the court improperly looked beyond the statutory text and rewrote the law. It further erred by deferring to a paragraph in the 2003 memorandum issued by the Office of Insurance Regulation to provide directions to insurers regarding changes that the legislature had made. And this is like a...
So your point is the trial court, the county court itself recognized there was no statutory requirement, but went beyond what the statute required, correct?
Absolutely. And of course, the law is very clear in this court and throughout the state of Florida. We cited cases from the Supreme Court as well as this court that you apply the plain text of the statute when it is unambiguous. It is unambiguous here.
Well, and you would also agree that the legislature knows how to say it because they have said it other places.
Your Honor, if you look toward the end of our initial brief, we talk about essentially what the provider is trying to do here is engraft the requirements of the uninsured motorist statute. And the legislature is very clear there, and this court and other courts have said that the uninsured motorist statute says you need to have this. Or, well, you actually can prove it other ways, but if you have the writing, that is the prima facie evidence. That's what you need. You need the insured to make this election, and you prove it through a writing. And so if you look in the policy here, you'll see there's the PIP deductible form, and then there's the uninsured motorist stacking coverage form.
So again, USAA's position, and I'm just reading from one of our many cases, Brooks versus State. In that opinion, we said, and when a legislative body knows how to say something but chooses not to, its silence is controlling. And that would be your client's position as well. The silence of the legislature and not overtly creating a form requirement would control our disposition of this case.
Absolutely, Your Honor, absolutely.
Meaning it's our duty to respect what the legislature didn't write.
Correct, correct. And what the trial court did here is it said, well, it didn't say anything, so let me try to figure out like what this, I mean, it said specifically there's silence here and I need to try to figure out why or something like that. And that's not the court's role. The court's role is to take the text of the statute, determine if there's ambiguity, and if not, and if it's silent, then there's no requirement. I would say that, of course, this is our position, but our position also, as I stated earlier, is the court shouldn't have even gotten to this point because you have a deductible clearly on the face of the policy, and it was incumbent upon the provider to challenge that. So the provider presented nothing to challenge that. And in fact, it said that it was our obligation as the insurer to prove that the deductible existed rather than once we presented the certified policy, their obligation to disprove it, which is incorrect. So.
Let me ask you about the court's judgment. The court did enter a fairly lengthy judgment in this case, right?
Correct.
One that was prepared by the provider.
Correct.
Many of the findings of fact and the legal conclusions broke in favor of the provider, and you're saying some of them were clearly wrong.
Some of them were clearly wrong, Your Honor.
And that is the reason why we constantly caution trial courts against adopting verbatim an order drafted by one side.
Correct.
That would have been a good issue for you to raise in rehearing. Did you?
Well, we didn't exactly say that. What we did point out, however, in some length, the rehearing motion is quite lengthy, all the errors in the order itself. I will agree the whole Perlow line of cases was not cited in the motion for rehearing. But in terms of the errors in the order, that was certainly preserved and discussed for pages in the motion for rehearing. The errors such as, for example, there was a discussion about whether whether the USAA had provided the proper notice under the deductible statute. And for whatever reason, the court concluded and the order stated that it did not. Yet that notice is part of the policy, the certified policy that was provided here. Not only that, but there was testimony from Mr. Segura, who is the underwriting witness, he gave both an affidavit and then was deposed, that Ms. Adams got an initial package and she got renewal package. She renewed this policy several times. And each of the renewal packets provided the proper notice. And that's shown on the face of the certified policy that, of course, is the document the court should have been relying on.
So the fact that there are these discrepancies with the judgment that was entered, I mean, that would lend credence to an argument that the judge did not use independent thought and analysis.
Absolutely, Your Honor.
Which again is more of a head scratcher why the line of cases, Pergolo, et cetera, is not included in the rehearing.
Your Honor, I can't really speak to that. I was not involved in the case at that point. But I do know that if the court were to reverse on that basis, of course, it would have to reverse with remand for the court to reconsider. Whereas if the court were to reverse as to the contract issue or the incorrect conclusion on the statutory issue, that the court should reverse with remand to enter judgment in favor of USAA. So perhaps, but again, I can't really speculate because I was not involved. Anyway, so back on the issues that we did raise, there are a lot of arguments from the provider about preservation, and while I understand Judge Harris's point about preservation on the Perlo grounds, all of the other grounds, it's very clear, were preserved. For example, they say we could not challenge standing, and yet that's an affirmative defense and was raised in the motion for summary judgment. That makes no sense. They say that we cannot raise the burden of proof, but that was discussed in summary judgment and on rehearing. And we recently filed a decision as supplemental authority, a very recent decision from the 4th District, which agreed with the 3rd District. So there are now 2 districts that have come out and directly said that a deductible is a part of a policy. And therefore, there is no affirmative defense that you are required to assert as a deductible. For example, exhaustion. Exhaustion you need to assert. But a deductible is a part of the policy, and once the policy is submitted to the court, as it was in this case, with a certification from the records custodian, that the deductible is therefore part of that policy. If the court has no other questions, I'll reserve the rest of my time for rebuttal.
Thank you. Good morning.
I'm a little shorter. Good morning. Your Honors, may it please the Court, I'm Dave Caldevilla. I'm here today with Rob Bartles. We represent emergency physicians in this appeal. Your Honors, the trial court order should be affirmed. USAA has produced no admissible evidence that a reasonable person could rely upon to conclude that the named insured ever selected any PIP deductible in this case, much less $1,000 or one that would cover the resident relatives within her home. The record demonstrates that USAA's 663 form, which is part of the policy and was approved by the Office of Insurance Regulation, instructed the named insured that in order to select a PIP deductible, she had to check the boxes on that form, sign it, date it, and then send it back to USAA. That form, again, is a component of the insurance policy, so regardless of what the legislature says in the statute, we do have a contract, and we have to pay attention to the contract. So
you would concede there's not a word in the statute about a separate form, separate notice, all the things the UM statute requires. You would agree the legislature has not seen fit in the PIP statute to include something related to a deductible like that?
So it's not the PIP statute, Your Honor. With all due respect, it's 627-739, which is the PIP deductible statute, but
All
it
right,
doesn't
well,
say that it has to be in writing, and I agree with you.
Let me just be clear.
sir.
The PIP deductible statute.
Yes, sir.
In the PIP deductible statute, and I'm sorry I overgeneralized.
No worries.
I know this is the air you breathe. The PIP deductible statute, there's not a word about something like what is in the UM statute, which is 727.9, correct?
They're different, for sure. And it doesn't say that it has to be in writing, but what subsection 5 does say of 627-739 is that such offers shall be made in clear and unambiguous language at the time of the initial application and prior to each annual renewal, okay? So there's a timing aspect. If they don't want to, I guess they can do it orally, but the statute does say that, look, at your option, you can get a form and get it approved by the OIR, and that will satisfy this statute, which is what they did. And you can use this 10-point font in your initial application form, and that'll be good too. So that's what they did. So let's be clear. Regardless of whether the statute says it has to be in writing or not, they opted to put it in writing, which is what the statute said they could do. So, and let's talk about the timing. Counsel over and over says that we presented absolutely no evidence of a violation of the statute, which, again, subsection 5 is very clear on the timing of this notification to the insured about their ability to elect. It has to be in clear and unambiguous language at the time of the initial application is taken. Well, we don't have the initial application in this case. They don't have it for some reason. I would suggest that if there was some material misrepresentation made on that application form, I think that USA would have no problem producing that application lickety-split. But in this case, it's gone. It's never been produced. The next part of the statute says, and prior to each annual renewal. You have to give it prior to, not at the time of renewal, not after renewal, but prior to. So then I take you to the evidence at page 2111 of the record, 2111. This is the deposition of Jose Segura. And here's the questions and answers about when this information was supposedly provided, which he has no personal recollection of or no knowledge of. But the question at page 4, this is a split four-way deposition transcript. I'm looking first at page 43, line 7. There's a question asked whether all the documentation, and I'm paraphrasing, whether all that documentation was provided to the named insured at the initial application and or renewals setting forth various deductibles offered by the defendant and the premium savings corresponding to the deductibles. And I'm going to skip down a few lines. Do you have any documentation that was provided to you at the time, or at the time of the application was originally completed showing what the various PIP deductible options were and the corresponding savings associated with those options? He says yes, but then he says at the time of issue, a policy issue packet was generated and sent to the insured, which did include the 663 form. That identifies the PIP options. So let's be clear. He was asked, do you have the application package? He says, no, I have the policy issue package. Those are two different things. The application comes before the policy gets issued. That's on page 43. The next set of questions have to do with whether USAA sent this notice prior to each annual renewal. And I'll take you to page 44 of that page of the record. The question is, but prior to that policy renewing, was any information sent to the insured? Answer, do you mean separately from the initial issue document? Question, right. So we've got the initial document, issue document, and by the way, I understood your testimony. I'm going to skip over. My question is, prior to that renewal deck page being issued, was there any information sent to the insured regarding the various PIP deductibles that were available for her to select and the premium of savings associated with that deductible? Answer, no, there was not. So we've got no compliance by USA on this record with respect to the initial application because they don't produce it. Then we have their corporate representative admitting on the record that no, they did not send this notice to them, or didn't notify the insured prior to the annual renewal, which is the plain text of Section 627, 739, which is what the legislature did put in the statute. So we've got a plain lack of evidence there. And we presented that evidence. If it was our burden, which I disagree, but if it was our burden, we did put in evidence. And we put in the 663 form, which is part of the policy. That form says if you want to select the options on this form, fill it out, sign it, date it, send it back to us. So it doesn't say,
Where's that mandatory?
I'm sorry, go ahead, Judge Harris.
Just where is it mandatory that that has to be done in order for the deductible to be chosen?
well, it's part of the policy, Judge, and the policy says this is how, if you want to elect a PIP deductible, do this.
It says, please check the box and send it back to us. I mean, I get a letter from my CPA every year saying, please check these forms so we can put it in your file. We have it for our records. Where is she required? What law says you have to do that in order to elect a deductible?
Well, Judge, all I can say is
It's
this
not
is what...
mandatory. This doesn't say what you say in here, where it's incumbent upon the insured to complete the form. It's requested that they do it.
Okay, so where's the evidence that she did it otherwise then? We have a deck page, okay, that says $1,000. We have a UM...
Isn't that evidence
It's evidence.
that it was done?
Yes, it is. So then we have a dispute in the evidence, at the very least, at the worst. We have a dispute. But let's talk about the deck page. It says $1,000 for the PIP deductible. It also says that this insured selected stacked UM coverage. The only piece of paper they produced concerning the UM election was that she selected non-stacked PIP deductible. So there's a mistake on this deck page with that. Let's say that she did check the box. Let's say she filled it out, or she called, or she typed it in her computer that she wanted a deductible, and it was $100 PIP deductible. And this, I'm sorry, that she wanted $1,000, let's say $1,000. And this form says she got $100 PIP deductible, another mistake. Would USAA be bound by that? Because what if it said instead of $10,000 liability coverage, it said $100,000 liability coverage, and that was a mistake? Would USAA be bound by this deductible page? How about if the premium, instead of saying your premium is $2,270 a month, to $2,270. What if it said $22.70 is your 6-month premium? Would USAA be bound by that? The answer to those questions, I believe, are no. The courts cannot enforce an agreement that contains terms and conditions that the parties never agreed upon, and mistakes are made. In this case, there's a statute that says the insured is the only one that gets to select the PIP deductible. They have records. They know what they're required to do. They got the memo. They sent their 663 form to the Office of Insurance Regulation to get it approved. They put it in their policy. They have no records. They say there was a telephone conversation. They say that there was a computer online election. Well, where is it? Where are the adjuster's notes about that alleged conversation? Where is the screenshot of the computer printout saying that here's how she made it, here's when she made it? So, Judge Harris, respectfully, we know that one way to elect a deductible is to fill out the 663 form. I think we can all agree on that. The policy is silent. They haven't produced one stitch of evidence that says you're allowed. We have internal policies that say we can make these changes by phone orally without anybody taking down a note or putting a note in the file. We have internal policies saying that you can make this election online. No evidence of that. All we have is a testimony of someone who says they have no personal knowledge of anything, but yes, this person made an online election. Okay. Best evidence rule? How about that? How about hearsay? Screenshot. Show us that that was done. We don't have any of that. If there's no evidence in this case, the lack of evidence is on their side. The only stitch of paper that we have that conceivably could be any evidence is that deck page, and we already know that it has wrong information on it with respect to the UM. What else is wrong on it? If there's a dispute in the evidence, then it goes to trial, right? We don't think that there's any admissible evidence to support the position that there was an election of a $1,000 deductible or any amount of deductible for Ms. Adams or for her child. But if there is some evidence on their side, if there is, then what we have is a dispute in the evidence which precludes summary judgment. On the burden issue, you know, I will admit I've discussed that quite a bit, but in this case, the parties have presented all the evidence that they're going to present. So I don't really know that it matters whose burden it is because both sides have produced evidence to the extent that it is what it is. But so if it is our burden, we did present evidence. We presented the blank form. That's evidence that this insured did not want a PIP deductible. It certainly communicates that message to USAA. And we have this deposition that I just went through, page 2111, that says that USAA did not comply with the plain text of subsection 5 of that statute. But the reason I make a big deal about this burden issue is because, quite frankly, I don't want this court's decision to come out like the third DCA and just willy-nilly say that PIP deductible is not an affirmative defense. This court's decision in St. Paul Mercury versus Coucher and the Florida Supreme Court's decision in State Farm versus Curran, which adopted this court's decision in Coucher, makes very clear what the test is for whether something is an affirmative defense in an insurance context. And according to that law, an affirmative defense, here's the test. It's a pleading that avoids liability in whole or in part by alleging an excuse, justification, or matter negating or limiting liability. That is the test adopted by the Florida Supreme Court. And all these cases, these third DCA cases primarily, and most recently I think the fourth that counsel cited in her supplemental authority, say, oh, deductible, that's not an affirmative defense, it's part of the contract. There's lots of things that are parts of the contract. That doesn't mean it's not an affirmative defense. For example, limitation of liability provision is clearly an affirmative defense. It's part of the contract. Counsel mentioned exhaustion of benefits. Well, when exhaustion of benefits happens, well, that is an affirmative defense. Well, wait a minute. Exhaustion's part of the contract. The contract says what the limits of coverage are. It's $10,000. That's part of the contract. How come that's an affirmative defense, but the deductible isn't? So if your honors are going to come out with a decision and say that the deductible is not an affirmative defense, then I would request that your honors distinguish the controlling law established by the Florida Supreme Court in Kern and explain to us all why that should be the plaintiff's burden, which is fine. Once we're all on the same page, we'll follow that law. But I think we have two different standards out there. Or we have one standard adopted by this court, and the Florida Supreme Court adopted it. And we have this other test, well, it's part of the contract, so it must be the plaintiff's burden, which I just respectfully disagree with that reasoning. You know, we've briefed other issues, and counsel hasn't brought them up today, so I don't know that I necessarily have to respond to them. I think that the issues are well briefed, but I do have some time left if your honors have any questions. Otherwise, I don't want to take up more time than you need me to. So, your honors, if there are no further questions, I would respectfully request this court to affirm the trial court's decision because there is undisputed evidence that no election was made. But if your honors feel like that deck page is enough, or there's some other evidence besides this blank 663 form and that testimony I just read to you, then we got to go back for a trial. Then there's disputed issues of material fact that we should have a trial. Thank you, your honors. I appreciate your time very much.
Okay, I just want to respond to a few points. So the first point, Mr. Caldevilla was discussing the form and saying that we're bound by the form, we created the form. But there's testimony that says the form, people can submit paperwork by paper, that is still allowable, but there also is the option to do electronic, and Ms. Adams had signed up to go through the USAA electronic system, or by telephone. Most transactions, well, I mean, let's just say many transactions. There's no evidence on this as to how many, but many transactions occur by either of those methods. And in fact, Ms. Adams, there is testimony that she utilized both. She made her initial application by phone, and she subsequently made electronic transactions, including adding her daughter to the policy. Second, let's talk about the timing, because I find this very strange. There is, again, a certified policy in the record. The certified policy has, I'll just show this to the court here, a little first page. This is the very first page here. Says Automobile Policy Packet. It is dated August 8th of 2018 for a policy start date of September 18th of 2018. And this was the policy that was enforced when the February 2019 accident occurred. I'm sure each of your honors gets information from your insurance companies when your policies are about to renew. The insurance company always sends that information before the actual renewal date. Mr. Caldevilla seemed to be suggesting that, in fact, this information came with the deck page came after the policy already renewed. No, in fact, it comes before that. And then on this first page, again, I'm still reading from that, it says, "Thank you for renewing your policy and allowing us to continue servicing your insurance needs. If you have any concerns or need to modify or cancel the renewal policy, please contact us immediately." So this gives the insured a period of longer than a month to make any changes if, in fact, she was dissatisfied with what was on the deck page. Then he talks about the records of the various transactions. At Mr. Segura's deposition, and this is in his transcript, and this is also referred to by the trial court judge at page 40 of the summary judgment hearing, there were approximately 2,000 pages of documents offered, submitted by USAA in response to the plaintiff's request. The plaintiff did not choose to offer any of those documents as evidence. The plaintiff also chose not to contact, well, I shouldn't say, we don't know whether the provider ever contacted the insured, but if the provider did contact the insured, what we do know is that there is no evidence that the insured ever disputed the deductible information. In fact, there is evidence to the contrary, because Ms. Verbal, the claim representative, who gave an affidavit and also was deposed, stated that she personally spoke to Ms. Adams, and then subsequently, after Ms. Adams and Ms. Frazier retained counsel, she spoke to the counsel and notified both of them about the terms of the policy, including the deductible, and there was no objection. Finally, in this case, the testimony, again, is that there were changes made to the policy by the electronic system. So when Mr. Caldevilla mentions that he saw a form, but that didn't necessarily correspond to exactly what was on the deck page, that could be because there were changes that Ms. Adams made when she made her online transactions. And if the court has no other questions, We would ask that the court reverse and remand with directions for entry of judgment in favor of USAA, not for a trial. Thank you very much.
Thank you. That ends our oral arguments this morning. It is still morning. Thank you both. It was well presented on both sides. We will now be in recess.
Rise.